Good morning, everyone. Welcome to Assembly Judiciary. We're going to go ahead and get started and welcome everyone here or those watching online or through, whether it's through Nellis or our YouTube channel. Also want to remind everyone to go ahead and turn off any kind of a volume or sound things on your electronics that could make noise or be disruptive. We will have a public comment at the end of today's meeting, and today we do have 3 bills scheduled to hear. So with that, Secretary, please take the roll.
Assemblywoman Bilbray Axelrod.
Here.
Assemblywoman Cohen.
Here.
Assemblywoman Considine.
Present.
Assemblywoman Gallant.
Here.
Assemblyman Gray.
Here.
Assemblyman Hanson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman LaRue Hatch. Assemblywoman Marzola.
Here.
Assemblywoman Mosca. Assemblywoman Newby.
Here.
Assemblyman Orentlicker.
Here.
Assemblywoman Summers Armstrong. Assemblyman Urick. Chair Miller.
Here, and please mark the other members present when they arrive. As I stated, we have 3 bills this morning. The first bill will be Assembly Bill 160. Assembly Bill 160 is presented by Assemblyman Miller, and do we have a co-presenter on Zoom today? Yes, okay, and also Commissioner Tick Segerblum. Assembly Bill 160 revises provisions governing the sealing of criminal records. So we'll give everyone a few moments to get settled and ready. And with that, I will open up the hearing for Assembly Bill 160. So please just take a few moments and then proceed when you're ready.
I don't know, can everyone hear me?
Yes, we can, Commissioner. Good to see you.
Okay, is CH, am I going to start first, or?
Give me just 1 second, Commissioner.
Okay, sorry.
Thank you.
There you go.
All right. Good morning. Good morning, Chair Miller. It's interesting saying that. I am Assemblyman Cameron C.H. Miller, for the record, and I am here today to present I'm from Assembly District 7, and I'm here to present Assembly Bill 160, which seeks to automate the sealing of eligible criminal records. I want to make clear before we get started for the record that AB 160 is not intended to expand eligibility for record sealing. AB 160 is simply about removing barriers for our constituents and making our record sealing process work for the people, making it more efficient and modernizing it. With that being said, I'm going to pass it over to Commissioner Tick Segerblum. I'm gonna get it right here in a second because he's got a meeting to get to and we want to make sure we get his remarks. Thank you.
Thank you so much, CH. Can everyone hear me?
Yes,
Great.
we can, Commissioner.
Okay, thank you so much. Good morning, Chair Miller and the committee members. I have to point out that I think at least 4 of you I share voters with, so it's very exciting to see you this morning. Thank you for considering this bill, and thanking you, CH, for letting me say a few words. By way of background, I served on the committee you're on today for 3 sessions, and I was the vice chair in 2011. Then I was the Senate Judiciary chair for 3 sessions after that. So I'm very familiar with what you do and the importance of the Judiciary Committee in the legislature. I also want to point out that when I was the vice chair in the Assembly, the chair was a teacher, wasn't a lawyer, Bernie Anderson. And truthfully, I think he's a legend, as you probably, Chair Miller, but he taught me so much. And I also think he brought a great perspective as a teacher that lawyers, we tend to focus on black and white and the letter of the law. And I think he brought a perspective of seeing the holistic part of laws and how they affect ordinary people. So I really commend you for being the chair of this. And also, of course, being a teacher, you know how to herd cats, which is part of your job here. It's been 10 years since Nevada actually started its marijuana program, where we legalized marijuana initially as medical and then later on as recreational. But I was involved in that, started in that process, and I'm very proud of what we did. But one of the products that we didn't deal with was the legacy of the war on drugs. The marijuana industry itself has been very productive, very beneficial, I think, but it's benefited in large lots of old white men like myself, and excluded really the victims of the war on drug, which are primarily people of color. And this bill seeks to kind of address that imbalance. It'll never be able to correct the wrongs of the past, but it does seek to at least address some of the issues which arose from the war on drugs, which are still lingering today. And that is the fact that there are thousands and thousands of convictions out there in our records and throughout Nevada in computer databases, which are still existing. And so if you go to apply for a loan, you apply to go to college, you apply for rent, all kinds of things, these things will pop up and most people don't even realize they're still there. So you can individually go out and have those removed through a painstaking process. And you have on your committee Assemblywoman Considine, who's the world's expert in this area, but she can tell you that it is a very cumbersome process. And so this bill seeks to figure out a way to address this on a large basis and wipe out lots of these convictions without having to go individual one by one. So it's a small step, but it's an important step, I think, to rectifying the war on drugs and the legacy. Because remember, right now, people are out there buying and selling marijuana, making money, having a good time, but we're within literally 10 years ago, people were being arrested, convicted, their lives were being ruined for something which now we recognize was wrong. So we need to figure out a way to rectify that wrong. And I think AB 160 goes a long way to do that. I won't get into the details of the bill, but I just want to explain how we got here. As a county commission, we collect marijuana taxes like you did. We were able to take a little over $200,000 and hire a firm called Code for America. It's a nonprofit out of San Francisco. They do this all around the country. They came in here and for over 6 months, looked at all our records, talked to the district attorneys, to the police, to the judges, to the public defenders, to everyone to see where these records are and to come up with this plan, which will enable us to eventually computerize a system where we can wipe these out, these convictions out. And so it's a very sophisticated process, but it's also a very cumbersome process. What we do is we allow, and this is being done from Utah to Connecticut, all around the country, the same thing is happening. But every city, every county has a different computer database. The state has a different computer base. So it's not like we can just have one computer program and run the system through it and wipe all these out. We have to go individually to each area and do it. So it's incredibly complicated. But again, as I said, well worth it to have this done. One of the legacies of the war on drugs, and to rectify what otherwise I think has been a very productive process with our marijuana industry, but to deal with the real victims of the past. So without anything further, I just would urge you to look at this bill very carefully. It's been crafted very expertly. I want to thank C.H. Miller for bringing it forward to you all, and anything I can do to assist you. Once we get to implementation, you're the policy committee, you're going to decide what to do, but it isn't going to be free. This is going to cost money to have this implemented, but we raise over $100 million a year in marijuana taxes. This is the perfect way to take those taxes and use it to rectify the wrongs of the past. Because I said, 10 years ago when people being arrested, now we realize that was wrong. It's a drug. I don't want to encourage anyone to use it, but the fact is it should never have been criminalized. And this goes up a large step towards rectifying that. So with that, thank you, Madam Chair, for allowing me to speak. I have to run off to my own commission meeting, but during the process, I'll be available if anyone needs my help. But I know you're in good hands with CH. Thank you so much.
Thank you, Commissioner. Assemblyman, would you like to walk us through the details of the bill?
Thank you, Chair. Yes. So, a couple of remarks I'll make, and then we'll get to the details of the bill quickly, and I will be quick. Currently, there are many circumstances in which someone may have their criminal record sealed. In general, to be eligible, someone must be released from custody, not under a suspended sentence, discharged from parole or probation, have met a statutory waiting period, and have not been charged with any offense since. I've included an exhibit that outlines those requirements. However, the process for a record to be sealed is overly cumbersome. As the commissioner mentioned, it is a difficult process. And while it's been the public policy of this state since 2017 to favor giving second chances to offenders who are rehabilitated, and the sealing of such records, our current petition-based process in Nevada is difficult to navigate. I've said that already, right? So I'm gonna cut to the chase. Several states, as the commissioner has mentioned, has already started to automate record sealing, from Pennsylvania to Utah, New Jersey, Delaware, Virginia, Oklahoma, Colorado. This is a bipartisan policy model that uses technology to automate arrest and conviction record clearance. The goal with this policy model is, simply put, it's about efficiency, modernization, and eliminating one more barrier to success for those who are rebuilding their lives. It has significant economic impact to those folks as well as to our state. And in closing, I'm going to go ahead and pass it over to Ashley Kennedy, who is with me today, who will walk through the details of the bill. Additionally, we have a representative from the Attorney General's office who may be here to answer some questions on an amendment that we consider friendly to this bill. With that being said, I will pass it over to Ms. Kennedy.
Thank you, Assemblyman. My name is Ashley Garza Kennedy on behalf of Clark County, and I'll walk through the meat and potatoes of the conceptual amendment. I will be going off of the conceptual amendment, and I will know what sections of AB 160 are not proposed to be changed. But to summarize, the bulk of the changes are going to be in Section 1 of the conceptual amendment. So to summarize, before January 1, 2028, the Records, Communication, and Compliance Division of DPS shall develop and implement a process to identify each eligible conviction and charge, as well as each agency of criminal justice that may be in possession of these records. Again, I want to reiterate the eligible charges and convictions referenced here are outlined in NRS 179.245 and can be found on the handout that Assemblyman Miller mentioned, which also includes a waiting period. Additionally, in Section 1, Subsection 8 of the conceptual amendment, a person is only eligible to have their record automatically sealed if someone has not been charged or convicted of any other offense except for a minor moving or traffic violation. Upon implementation, the division will identify and compile a recommended list each month of each conviction or charge against a person eligible to be sealed, and transmit that recommended list to the Administrative Office of the Courts of the Nevada Supreme Court. I want to note that in Section 2, subsection 2C, the addition of NRS 179.259 and NRS 453.3365 to the list of eligible convictions and eligible charges. For clarification, under NRS 179.259, a person may have their record sealed 4 years after completing a reentry program. This currently does not require a petition, but is at the discretion of the court. This change just ensures that these records are captured in this automated process as well. In that same vein, under NRS 453.365, a person may have their record sealed 3 years after a conviction related to the possession of a controlled substance without the intent to sell. These records additionally can be sealed without a petition, but it is at the court's discretion. Not later than January 1, 2028, the Administrative Office of the Courts shall develop and implement a process to review, approve, and transmit to each court of jurisdiction the eligible persons identified for record sealing. Upon implementation, the Administrative Office of the Court shall notify each court of jurisdiction within 30 business days of the eligible convictions and charges. The court with jurisdiction shall notify the prosecuting agencies within 15 calendar days of the records that will be sealed, at which point prosecution can object to the notice within 30 calendar days. If there is no objection, the court shall order all of the eligible records sealed without a hearing, and each entity identified as having possessions of that record shall be named in the order. If prosecution does object, the court may set a hearing. I want to make clear that currently during the petition-based process for record sealing, the prosecuting agencies have the authority to object. Thus, this conceptual amendment seeks to keep that ability. At a hearing, the prosecution has the duty to present sufficient evidence that rebutes the presumption set forth in NRS 179.2445. Currently, there's a rebuttable presumption that if someone has met all of the statutory eligibility requirements for record sealing, that they in fact should have the record sealed. The division and the administrative office of the court shall take any action necessary to ensure public awareness of automatic record sealing and may contract with any vendors or apply for any grants to carry out the provisions of this section. Additionally, the implementation of automatic record sealing does not remove anyone's ability to still petition the court to seal their eligible records, and if someone believes that they may have had their record sealed through this process, they will also have the right to confirm and review their sealed record. Lastly, a year after implementation, the administrative office of the courts shall yearly report to the legislature records identified as eligible and the number of records that were ordered sealed. Section 2 and Section 3 of AB 160 are conforming changes, and no changes are proposed in this conceptual amendment. Section 4 of AB 160 allows someone to seal their arrest record related to any charges which were disposed of by dismissal, declination, or acquittal. Section 5 of AB 160 is conforming changes. Section 6, subsections 2 and 3 of AB 160 relate to the documentation the court must provide upon sealing someone's record. As more records are sealed under the provisions of this bill without the need for a petition, we may not have a way of notifying someone their record was sealed. Thus, these changes proposed in this section will remove the documentation requirement for persons who had their record sealed automatically. However, a person may file a written request with the court to verify that their record was in fact sealed and to have the documentation that their civil rights were restored. Section 7 and Section 8 of AB 160 are conforming. However, I do want to add clarification in Section 8. Currently, based on federal state law, there are convictions in which someone may be prohibited from carrying a firearm. The conceptual amendment in this section clarifies that DPS can inquire and inspect any records that were sealed to comply with those provisions, which are in NRS 202.360. Referring to the conceptual amendment again, I want to walk through a few additional proposed changes that are not in AB 160. First, we seek to create a task force of individuals from this body and criminal justice agencies in the state to oversee the implementation of automatic record sealing and periodically report to the legislature. Secondly, given the long implementation timeline of AB 160, we want to ensure that we don't want to remove anyone's right to still petition the court to seal a record. And it is proposed that the administrative office of the courts may develop any type of regulation or rule to streamline the petition-based process during the implementation period and after, because we hope that we want to keep that right for folks to still petition if they would like to. Third, to automate record sealing, the agency tasked with identifying eligible cases must have up-to-date and accurate records. NRS 178.075 outlines the various records required by each criminal justice agency that need to be kept and how and when those records need to be communicated to our state's records division. Thus, the conceptual amendment just asks the legislature to declare the public policy of the state to enhance and modernize information sharing. Finally, the conceptual amendment seeks to clarify effective dates in Section 9 of AB 160. That's the meat of the and potatoes of the bill. And in conclusion, I just want to reiterate a point that Assemblyman Miller made earlier. The goal of this legislation is to take our existing policies around record sealing and remove the lengthy petition-based process. If someone has met all the statutory requirements of having their record sealed, then those records should be sealed without the red tape. That concludes my remarks, and we'll stand for questions.
Thank you for your presentation. I'll just give members a moment to prepare their questions. One thing that I would like to start with is if you could just share the actual benefit. Assemblyman Miller, you spoke when you opened about the benefit about removing barriers. Could you just maybe just give us a few sentences about the impact that this will have on individuals and the public?
Yes, Chair Miller, thank you for the question, for the ability to do that. I just really quickly start by saying that there's a report by the Center for Americans for Progress that says 9 in 10 employers, 4 in 5 landlords, and 3 in 5 colleges and universities now use background checks to screen out applicants with criminal records. A criminal record can be a barrier to economic prosperity. So with that being said, being able to have an automatic process after you have already served your time, been rehabilitated, and been cleared by our statutes that already exist that say you should be eligible to have your record sealed. We want that process to automatically start, to not create any additional barrier for those folks. When we look at what it takes to build a life, and now we're looking at someone having to rebuild it, we want them to be as successful as they can possibly be, so that reduces recidivism and a need to go back to do anything that brought them into that position where they found themselves needing to have a record sealed, right? So the benefit for the individual is the barrier is removed. They can start to finally put their life back together in a more expeditious way. The benefit for us is a streamlined process as a state, as government, that can bring about efficiency and how we handle our resources and human resources within our agencies differently to make sure that our government is actually working for the people. Thank you.
Thank you so much for that. And one additional question before we open it up for member questions. Ms. Proctor, would you walk us through the AG's amendment as well?
Thank you. For the record, Heather Proctor, Heather Procter, Chief Deputy with the Nevada Attorney General's Office. The Attorney General's Office submitted a proposed amendment to AB 160 to include in sections 5, 6, and 7 references to NRS 41.910, which addresses wrongful conviction compensation cases. The legislature created this process in 2019. If a person is successful in obtaining a certificate of innocence under the wrongful conviction compensation statutes, their criminal records will be sealed pursuant to NRS 41.910. I would note a sister bill in 2019 created the ability for defendants to file a factual innocence petition, which, if granted, will also lead to the sealing of the criminal records under NRS 34.970. Sections 5, 6, and 7 of AB 160 already include NRS 34.970 in the statutes. We seek to include NRS 41.910 for wrongful conviction compensation matters as they address similar basis. We therefore seek to amend Sections 5, 6, and 7 of AB 160 to provide persons who prevail on a wrongful conviction compensation complaint the same ease of access and ability to address records held by the Criminal History Repository, restore the individual's civil rights, and to inspect sealed records. If these individuals obtain a certificate of innocence leading to the sealing of their criminal records, they should have the same rights as others whose records are sealed by the court order if they prevail on a factual innocence petition. We therefore submit the proposed amendment to include NRS 41.910 in AB 160, Sections 5, 6, and 7. Thank you.
Thank you for that. And Assemblyman, I'm assuming those are friendly amendments as well, considering you're at the table together.
C.H. Miller, for the record, yes.
Okay, thank you. With that, we will begin our member questions. First question will be from Assemblywoman Gallant.
Thank you, Chair. I appreciate where you guys are coming from on this. I do think we need to be able to give people like a fresh start. But I guess not being an attorney and we're using the term automatic, a lot of us are like, okay, so we press a button and it's done. So I'm curious, what does the process look like now? Because it seems like the person who wants the record sealed has to initiate the process, and then who assists them with that currently. And if this was to take place, which department is assisting it, and like what does that process look like for them, and is that something that they can handle?
Assemblyman C.H. Miller, for the record, Chair, is it okay to go directly to the member?
Yes, please.
Thank you. Thank you for the question, Assemblywoman Gallant. So I will quickly go over the process a bit. I am also not an attorney and got a crash course in understanding just how cumbersome the process is. And it starts with a petition to the court. And to make this petition, you must have all of your criminal records from all of the agencies, which requires the individual to go on their own to each one of those agencies to get the necessary information and verify it. And then when they go to each one of those agencies, each process is manual. So it requires that agency to then go through, verify, do all of those checks, and get the information to them, which can take months at each agency, right? It can take an extended period of time, and I'm sure there are folks in the room who are more familiar with the process that will be able to correct and clean up anything that I misspeak, and I invite them to do so. But at the end of the day, they have to go through this. No one assists them unless they seek their own legal counsel to do it. So it becomes costly for the individual and timely, very timely, time intensive. And then it's also labor intensive on each one of the departments or the agencies that have to prepare the records or the information.
And I will also just note Ashley Garza Kennedy from Clark County. Assemblywoman, I would say this process is really hard to do without legal representation. And Michigan recently passed what we call clean slate. And they did a study and found that 90% of the people who were eligible to have their records sealed did not do it just because of the burden.
With that, just because I know there's more questions on the actual process, and this is what we're getting at, I would like to call Public Defender John Pirro up, if you could, because I know he has spent a lot of time in this process. So if you could just, Mr. Pirro, respond to that question as well. Thank you.
Thank you, Madam Chair. John Pirro for the record. And Assemblyman Miller is correct. It is a patchwork of laws. It is much better than 2014 when we first started this process, and this body has done a good job of making it similar, but it's still very difficult. I can tell you that personally, I'm working on 6 cases pro bono, but each step of the process takes a long time. First, you have to get your criminal record from the repository. That could take up to 6 to 8 weeks. They say 45 days, but it could take a long time. Once you get that, you should probably go to each agency that arrested you and get a scope report just so you have an accurate accounting of what the criminal record takes. That entails you getting fingerprinted, going there, getting each record from each agency. Hopefully it's only one, like Metro. But if not, you may have to go to Henderson, North Las Vegas. Then you have to figure out where the charges are. Are they in Las Vegas Justice Court, Las Vegas Municipal Court, Henderson Justice Court, Henderson Municipal Court, North Las Vegas Justice Court, North Las Vegas Municipal Court, Mesquite, Laughlin? Where are all your charges? Where can we put those down? Have you met the time periods? Then we fill out the packet and the paperwork, and then we send it to the prosecuting agency. That could be the district attorney's office. It could be the Henderson City Attorney's office. It could be the Las Vegas City Attorney's office. It could be the North Las Vegas City Attorney's office, and each one of them have little peculiarities that they like. And then you put that packet in with them, and then you got to wait for their ability to process that packet, even if you've met the time frames. Then once you get that back, then you can submit it to the court. And if the court decides, then the court will have a hearing. After you do all that, then you have to mail it back to each agency, the Department of Public Safety. You hope that they're gonna mail it to the FBI and get that there on time, so that is also sealed. And you mail it to each police agency and each court where you were convicted, and hopefully by the end of a year's time frame, year and a half, you have your record sealed. This process here would streamline it in the most efficient manner.
Thank you so much for that. Assemblywoman Gallant has one more additional question.
Thank you, Chair. So it sounds arduous now, and I'm sure all of that court stuff has to continue to happen. So how would it streamline it? Who would be responsible for it? So, I mean, what does that look like if this passes, like in the real world?
I thank you, Ashley Kennedy from Clark County. John Pirro and I will continue going back and forth with his legal expertise. So I think the process of how it would look if this were to pass and move forward is that petition-based process would cease to, well, not cease to exist, but that this process would happen automatically in the sense that like all of the systems are working together. Now, I will be frank that there are, it would be a perfect world if all of our criminal records were in the same system, but that's not the reality. But I will say in other states like Oklahoma and Michigan and California who have done similar things that have disparate systems like us that are all over the place, they have been able to make this work throughout the implementation. But ideally, it would be the systems kind of talking to one another through this process, rather than the petitioner going through the process itself, if that makes sense. There will need to be technology and system upgrades in order to make this happen.
Assemblyman C.H. Miller for the record. I just want to add to that. So this is also a part of why we would have the task force or working group implemented to make sure that we're able to streamline a process and a future implementation date, which is a day forward provision on conviction. So what this working group would do is all of the stakeholders will come together, figure out what's the best process, and then on the day one, we would start, convictions would be eligible for automatic sealing at that time. It is not going to be, automatic doesn't mean easy. It doesn't mean simple. It just means it begins to happen. And so that's what we want to see happen. Obviously, technology, we need to modernize so many of our systems so that technology can assist us to be efficient in processing. And so even in communication, so many of our departments and agencies don't communicate with each other. So if this process can lead our different departments and agencies to start communicating more efficiently and effectively when there is a case that can be followed through a system, then that helps us in just the efficiency of how each agency and entity would work, but then it would also help us with the automation process so that it wouldn't be such a cumbersome process for the entities as well as the individuals.
Thank you for your question, Assemblywoman. Our next question is from Assemblywoman Cohen.
Thank you, Chair, and thank you for the presentation. You mentioned in your presentation Code for America, the not-for-profit, and then throughout the bill there's references to or private company, which I assume is right now Code for America. Who's choosing, can you just get more into the concept of utilizing a private company, and is that going to be the task force that's choosing the private company, or who's going to kind of be overseeing the private company? Because a lot of us get a little squeamish when we're kind of ceding some of our responsibilities to a private company.
C.H. Miller for the record. Thank you for the question. I'm going to start this, and then maybe my partner here, Ashley, will finish it. But as of right now, Code for America just did the study. They are not a part of this process where we are right now. So moving forward, the task force, the group, would be able to find the best entity to assist us in implementing our automatic record sealing process. As of right now, that is not Code for America in this process. That is not, there's no expectation for it to be Code for America. Thank you.
Ashley Kennedy, Clark County. And I also just want to reiterate too that the DPS, for example, our Department of Public Safety and our Records Division is currently actually going through a technology modernization process. And so they're working with a vendor to update their systems. And so this conceptual language around the ability to contract with a vendor was really just kind of with that in mind, that there are vendors out there who work on work on criminal justice records and giving the ability for that process to move forward. And as the Assemblyman mentioned, the task force, we envision it as an implementation task force who would be tasked with reviewing and approving anything regarding contracting with a vendor, applying for grants, et cetera.
Thank you for that. Our next question is from Assemblywoman Hanson.
Thank you, Chair. Good morning. And I certainly appreciate, actually, I appreciate you, Ms. Kennedy, coming and speaking with me about this. I appreciate that people need a second chance, and proud that in our small business, we really do work to try to do that, because a lot of these individuals don't have the records sealed, and then we have to have some conversations and work through that. But I know that's not always the case. And so, if I could have you just clarify that I got this right, and then I actually do have a question. Trying to understand the process for everybody, because I felt like, Ms. Kennedy, you helped me to understand it, and I had made some notes. So if I could kind of repeat those and then let me know if I got it right. So the central repository would then create, the names would then go through from them over to the administrative division of the courts. And that list then is looked at, and then they notify the prosecuting agencies of the names, or to the district court and the prosecuting agencies to look at those names. And then there's a 30-day window for appeal. Like if there's a name on there that the prosecuting agency or the district courts don't agree with, they have 30 days to go ahead and appeal that, and then that process happens. And then if there is no problem within that 30 days from the prosecuting or the district courts, the automatic seal takes place. So there is kind of this flow through that I felt comfortable with. I don't know how well that will work out, because I know it's going to take a while. But, and also to emphasize, this bill seeks to change processes, not policy, which I think is a really important point to make. And so my question on this wonderful handout, I love handouts. I just want to make sure I understand, we look at the waiting periods under Nevada law, the ones that are in red. And we've talked with the commissioner about marijuana, some of these drug offenses, but now we're not just talking about that. We're talking about other very serious crimes. The waiting periods don't change. It's just the automatic sealing. And then we do still have those offenses that you don't ever get to seal your record. Sex crimes against a child, DUI that results in a homicide, watercraft that ends in a homicide. So those all stay in place. Waiting periods stay in place. We're just trying to get this process worked out, right?
Ashley Kennedy, Clark County. Assemblywoman Hanson, that is correct, yes. So there's multiple checks and balances through this ideally automated process where DPS would be identifying folks that are eligible within their system, having the administrative office of the courts confirm that is in fact somebody, a charge or conviction that is eligible, and then letting the court that has jurisdiction over that case. So wherever that case was charged, whether it was district court, justice court, letting them know that these are the ones that are to be sealed, and at that point, prosecutors have the ability to object. That is currently how the process exists in the petition-based, that the prosecution does have the ability to object within 30 days. What you said about we're changing process, not policy, that is correct. This handout that the Assemblywoman mentioned or all of the offenses that are eligible after a certain window of time. So for example, if you were convicted with a category B, C, or D felony, you have to wait 5 years from your release of custody or discharge or parole or probation, whichever one's later. And you also you couldn't have been convicted of another charge since then. So all of that will remain in place, everything that exists. Nothing has changed as far as what you mentioned, as far as the crimes that are not eligible for sealing. will remain the same. It really is just about the process, and rather than somebody trying to navigate the system, that the system is working for the person.
Thank you. Our next question is from Assemblywoman Summers Armstrong.
Thank you, Madam Chair. Thank you, Assemblyman C.H. Miller, Ashley Kennedy, Mr. Pirro. Really appreciate this. This has been an issue in the community a long time, and it's wonderful to see the tremendous work that you all are doing to work together to move us another step forward. I don't have a concern, though, and that concern is about once records are out in the atmosphere and how we, what types of expectations we have from people who use court data as a business. How are we, or has there been any thought about how regularly people who use court data will be required to come back and revisit in order that folks who are having their records sealed, we know it takes a year or more, don't go out and believe that their records are sealed, and then only to find out that there's some case somewhere that didn't get done, and they're unable to rent housing or get a job, or any of the other things that we're trying to correct here. So could you talk a little bit about what are the requirements if someone has a business that is allowed into the repository or whatever system is, I think it's Scope or something. How does that work now?
Ashley Kennedy, Clark County. And you bring up a good point when we talk about, and I will let my colleague Piero correct me if I'm wrong, when we talk about sealing versus expungement. And there are private companies that could have your criminal record in the sense of, I'm sure you've seen them on Googling, someone's record. These are these private kind of companies that are using that. During the seal process, there is a hope that those records that are housed with those private companies are captured, and that is one thing that I think our statute and the conceptual amendment tried to address. However, those records aren't expunged. However, for the purposes of somebody getting their record sealed, if your record is sealed for that particular conviction or charge, whether it's a partial seal, meaning some of your charges were sealed and some of them weren't, or some of the convictions were sealed and some of them weren't, you have a right that record is sealed, and therefore you have the rights of that record does not exist anymore when filling out an application. And my colleague Piero, do you want to correct me on anything? Okay.
But so what I'm understanding is that it's a hope, but it's not necessarily going to be a catch-all, that we can still have employers or banks or other people who have access to see that and still deny a person a right that they should have. And if that is true, is there any recourse for that person if they find out about it?
Assemblyman C.H. Miller, for the record, I would suggest that our working group would be able to further study and implement a plan to address that particular issue directly.
And John Pirro, for the record, there are certain groups that do get the ability to look past the ceiling, and for good reason, like the nursing board, police agencies. So there's certain places where these records are not, like they're out of public view, but some agencies will still have the ability to see that something happened.
Ashley Kennedy, and just to also clarify too, currently when you go through the petition-based process, you receive documentation that your record was sealed, that your civil rights were restored. The conceptual amendment, because this will be an automated process, we may not have contact information for folks, but we want to be able for folks to still inspect their sealed record. And in the event that somebody did have their record sealed and there were stipulations on any type of background check for anything, they will be able to make a written request with the court to show documentation that record was sealed.
Thank you. Our next question is from Assemblywoman Hardy.
Thank you, Chair. Thank you for bringing this bill. At one time in my career, I worked in justice court and would have these individuals come in with all of their paperwork, hoping to seal their records, and it was sad when we had to reject them and say, you're missing this or that, and they had to go back and, just like we've mentioned, an onerous process. So this will be so wonderful to help these individuals. If you would, you mentioned you extended the timelines for implementation. The original bill was 2024. If you would just go through the new dates, effective dates, because there's several different ones, and then just comment. I assume that you chose those dates so it gives time for all of these different entities to be able to have the technology and all these things we're talking about. And do those groups feel these dates will work, that most of this will be ready? Thank you.
Thank you, Ashley Kennedy. Assemblywoman Hardy, I'll walk through the dates. So I think the biggest date as far as when this would theoretically go live would be 2028. And that date was chosen based off of feedback from our Department of Public Safety, who, as I mentioned earlier, is going through an IT modernization program that should hopefully be done by next year. This gives them the ability to finish that project before starting a new one, because while they think that their systems could support any changes to lead to automation, that will still require tech upgrades. So that's where we landed on 2028 for this to go live. There are some other dates as well that you mentioned. So beginning January 2029 is when we will start getting regular reports from the Administrative Office of the Courts as far as how many records we're talking about yearly. The task force will begin as soon as this bill is passed, with the hope that in 2024 and 2026, so before the 25 and 27 session, that they're reporting to the legislature how the implementation's going and if there are any changes needed, whether that's technology support or statutory support in order to make this process work. And then if the Administrative Office of the Courts moves forward with a more streamlined petition-based process in the interim during the implementation process, or moving forward for anyone who still does go through the petition process, hopefully that will be done by 2025.
And C.H. Miller, for the record, I would just say, in full transparency, not every agency or department has signed off or agreed to these dates, right? Sometimes when you are proposing significant change and transition, there's an immediate halt to, wait a minute, this is going to be a lot. It will be difficult, it will be heavy, but it will be worth it. And so even though it is challenging to say, oh, we're going to have this implemented by this date, that's the purpose of the working group, to try to make sure that all of the entities that need to be a part of the conversation are a part of how they can get their agency ready for these implementation dates. And if we need to make some adjustments, we look at what that looks like, maybe on a case-by-case basis on how people come online into this process. But as she stated, we started with where DPS was in their automation process, and then built out from there what we thought would be a reasonable implementation timeline for the entire process.
Thank you. Our next question is from Assemblywoman Newby.
Thank you, Madam Chairwoman. Thank you for bringing this incredible bill. It's just brilliant. But my question is, beyond the obvious benefits to the individuals, which are many, I imagine that this also streamlines a lot of work at the local jurisdiction level and for the courts. not having to go through this process on and on. Ms. Kennedy, can you speak a little bit to the efficiencies that may occur because of that?
Yes, Ashley Kennedy, Clark County, and I will also defer to Mr. Pirro, who I know who has worked in this field and has done this himself for years. While I want to note that I understand that this is a big change, process change, and that there could be some challenges getting this up and running. However, when all of that is done, ideally, this should be automated and be an easier process, less review by all the different criminal justice agencies that are involved, from law enforcement to the courts to the repository to everybody involved in the system, that it would be a lot less labor intensive once we get there. I recognize that currently there is a lot of manual work that goes into the record sealing process, and we hope to get to an automated process where there is very little manual work that goes into this process. Mr. Pirro, do you want to talk anything else? Okay.
All right, thank you for that. Thank you for responding to the questions, and thank you for joining us, Mr. Pirro. With that, I will open it up for testimony. I know there's a number of people here that would like to testify on this bill. I'm a bit disappointed that the youth left us, because those in the room know that we were packed with young adults for a moment, but I'm glad they were able to absorb the part of the hearing that they could. So with that, I will open it up first here in Carson City for anyone who would like to testify in support of Assembly Bill 160, asking that everyone keep their comments to 2 minutes.
John Pirro from the Clark County Public Defender's Office. Thank you, Madam Chair. And I want to just thank Assemblyman Miller and Ashley Garza Kennedy for their tremendous amount of work on this bill and making this bill make sense and streamline it. I've been working in this process with Judge Yeager now since 2014, and we worked with legal aid, and we got everybody in a room, and we tried to make the process less onerous. And since 2017, this body has helped tremendously in making it less onerous, because that was probably a pretty sucky part of our job when we started. Was we saw people cycling through the system. We wanted to figure out a way to stop that cycle. And then there was a lot of heartbreak with how difficult the record sealing process was. So then we would see tears on the back end as well as the front end. This body has helped us move forward in that direction, but this would definitely streamline the process and put a lot of people in a better position to get back to work, get their lives back, and move forward and become a part of our economy, which would be better for all Nevadans. So thank you for this measure.
Thank you so much, and I think you were referring to Judge Beta Yeager, not Speaker Steve Yeager, correct? Okay, thank you. Also, just to remind folks to say and spell your name, please, as well. Thank you.
Chair Miller, members of the committee, Jonathan Norman, Norman. I'm with the Nevada Coalition of Legal Service Providers, which includes Legal Aid Center of Southern Nevada. We have been involved from a grant from the Clark County Commission in record sealing starting in 2022. And to put it into perspective, in Clark County, we have one attorney at Legal Aid Center who handles these cases, and we have one attorney at Nevada Legal Services who handles these cases. And when you think, and then we have, good pro bono attorneys like Mr. Pirro, who are able to take cases. But if you think of the population of Clark County, and you have 2 attorneys, and then we put on clinics where we engage pro bono attorneys, the number of people we're able to reach versus how many people are eligible, there's obviously a big gap between those two, and it is labor intensive. I can share with the committee, and we have information on our Self-Help Center website about the process, and at every point, Mr. Pirro referenced 45 days to, is the ideal to get the information from the criminal repository, but it can run 6 or 7 weeks, and the whole process, once they get to legal aid with all their documents, can be an additional 6 months to a year. So it's significant. And then I also just wanted to mention, Assemblywoman Summers Armstrong had mentioned the idea of companies, and I think what she's referring to is companies scraping data from our court websites. And the question is, how often are they re-querying or re-scraping that data so that they're not eliminating people based on information they scraped 2 years ago? And I think that's a really worthwhile discussion because, with a credit agency, you have the ability to correct your credit report. I'm not aware of a similar mechanism for correcting those third-party private databases. And so I think that, and I'm very happy that Assemblyman Miller took that on and said that they would be able to look at that, because I think it's important. Thank you.
Thank you, Chair Miller and committee members. My name is Nick Shepak, N-I-C-K-S-H-E-P-A-C-K. I'm the State Deputy Director of the Fines and Fees Justice Center. As an organization that works to eliminate fees in the criminal legal system, we are here in strong support of this bill. We want to thank Assemblyman Miller and Commissioner Sagerbloom and the other presenters for being here today with this important piece of legislation. As Assemblyman Miller mentioned, the process for record sealing is arduous, it is confusing, and from our work, we know that it can be very expensive and the barriers are many. It is our job as a state to recognize those barriers, and when we find people who are working to get their lives back on track and working to take care of their families and become productive members of society, it is our responsibility to remove many of those barriers. In fact, it is our duty. We have created a record sealing system in this state with the understanding that individuals deserve a second chance and should have their records sealed. However, the system now is a two-tiered system. If you have the finances and the resources, or if you were lucky enough to get pro bono representation, you can move forward with the record sealing process. However, as we heard, in one state up to over 90% of individuals failed to utilize this process. When we make laws in order to give people a second chance, laws that we believe in but don't create a pathway for them to actually work, that's very problematic. And so we see this bill as a fantastic solution, and we urge your support. Thank you very much.
Good morning, Madam Chair and members of the committee. For the record, my name is Annette Magnus, and I'm the Executive Director of Battleborn Progress. I am here today to show our support for Assembly Bill 160. Individuals who are found guilty of certain crimes should not be marked with a scarlet letter for the entirety of their lives. The drug war has done significant harm to communities of color, and this bill will begin to right that wrong. Applying for a loan, applying for housing, applying for a job, applying for social assistance, all of these things are prohibited or made much more difficult for individuals who have been convicted of a felony. This cannot continue. I urge the committee to pass AB 160 and begin to right the wrongs of a misguided criminal justice system that has done so much harm. Please support this important bill. Thank you.
Good morning, Chair and members of the committee. My name is Erica Roth on behalf of the Washoe County Public Defender's Office. I echo the sentiments of those who've come before me and testify in support of AB 160. Justice means nothing without access to justice, and this is a first step to ensure that everyone who has completed their time, paid their debt to society, is able to move forward and access the resources and basic needs that they deserve. Thank you.
Good morning, Chair and committee. My name is Aisha Goins, A-E-S-H-A-G-O-I-N-S, and I am here on behalf of the National Advancement for Color People, National Association for the Advancement of Color People, and also CEIC, which is Cannabis Equity and Inclusion Community. I want to thank Assemblyman Miller for bringing this bill. It's such an important piece, especially as it relates to the work that both of those organizations do. Desmond Tutu says, "My humanity is bound up in yours, for we can only be human together." Nothing challenges my humanity more than the apparent obstacles and fees that impacted and poor people have to pay. I'm challenged because there never seems to be an alternative, but I hurt because my family and community is still impacted. The saying is, being poor is expensive, but being formally incarcerated and is also generationally expensive and impacting. This bill is important in relieving cost and restoring impacted folks. It allows impacted folks the opportunity to begin again. And in our humanity, that's what we should be able to offer everyone, is to begin again. Thank you.
Not seeing anyone else here in Carson City. Broadcasting, please open the lines for those who wish to testify in support of AB 160.
Callers, if you would like to testify in support of Assembly Bill 160, please press *9 now to take your place in the queue. Again, if you would like to testify in support of Assembly Bill 160, please press star 9 now.
Good morning. Jim Hoffman, representing Nevada Attorneys for Criminal Justice. We support this bill. I have also done pro bono record sealing, and from my experience, there are a few specific groups of people who would really benefit from a bill like this. First group is people who used to be homeless. The second group is people who are either voluntary sex workers or who were victims of sex trafficking. The third one is people who used to have a substance abuse problem but were able to get clean. Those are all groups of people who can pick up large numbers of criminal charges at a time when their life is not going so great. Then when they get out of that life, they get sober or get housing or escape from being trafficked, they still have all these charges on their record. That makes it harder for them to get employed, get back into school, and unfortunately, it makes it easier for them to slip back into the bad old life. We have a process for sealing those records and helping those people, but as was testified, it's a very arduous process. And at a time when people are doing this very difficult work of moving out of homelessness, getting sober, building a life after being trafficked, we don't think it's good policy to also put this extra bureaucratic burden on them. We think it should be streamlined and automatic because that's the best way to help people move forward. So we support the bill. Thank you.
Thank you.
With the last 3 digits, 517, you are unmuted on our end. Can you unmute your phone? You may begin.
Good morning, Assembly. This is Anna Binder, ANNABINDER. I'm a retired paralegal of over 25 years, and I cannot begin to explain the people in our community that will benefit from the automation of this process. So I echo everything that's been presented today. However, throughout my career, if we took it back prior to 2017, file only in the district court. And I believe there could be a mechanism under the law to potentially send something that's comparable to like a notice of creditor that goes out in probate cases to the other jurisdictions to let them know that this is being done and give them, preserve that time for them to object. That would mitigate the unnecessary multiple filings in multiple jurisdictions for those in the population that have that. We really had was the district attorney's office who would approve. They had to approve the petitions, and back then there was only really one employee that did that. So that could be a 90 to 120 day turnaround. And when things get kicked back from the courts, it only takes a couple of days to make corrections and kick that back. So as we're trying to make things easier, it really just, since 2014 and coming forward in my professional career, the laws made it much more difficult. So I really look forward to seeing how the automation works, and I wouldn't mind participating. I'm also a previous Justice Court employee, so I'm know the burden of the systems. But I really just think that this is simpler, not harder, and we could streamline it if we went back to some of the old ways. Thank you very much.
It really just Chris Giuntiliani, Giunchigliani. Thank you so much for, Madam Chair, members of the committee. Thank you for bringing this bill forward. It was 23 years ago that I wrote the first and passed the first automatic sealing of records bills. And unfortunately, or fortunately, I also included policy in that. So now this one's pretty clean. You don't have to worry about the timelines. We did that back in 01 and 03. The sad part is it was undone and changed over the years, and it made it much more difficult, and the automatic part of it never got implemented, in my opinion. So this bill is much needed. Secondarily, I would urge you strongly to eliminate the word charged or convicted. Charging, someone has been charged. You can be picked up and put in jail for 1 day. You're charged. That stays on your records. And most people don't know that. And yet you've never been convicted of anything. taking that wording out throughout would really focus on the issue of you've been reconvicted again, then your eligibility changes. I would also point out in 179.245E, domestic violence, take a look at the timelines on that. Sometimes in the old days, the woman who made the call was also charged. And so that goes against her record, even though she was not the guilty party. So we need to look at that part of it. I would say what Senator Neal used to tell me, justice delayed is justice denied. And so justice means completing an opportunity for people to participate back in society after they have paid their debt. In addition to that, I would suggest that you establish a fund currently, put some of the money, as the commissioner recommended, from the MMJ, go to the courts, they won't be happy, but peel off one penny or something and put that into the fund to begin paying for the money when it's ready to go automated. And finally, I would suggest that you look at your go live date, that don't prohibit it from being able to go sooner if you get everything lined up and you're ready to go. This has been a barrier for occupational licenses, adoptions, foster care, CASA, employment. All of this keeps people down. And if we really want to move this country and everyday people after paying their debt to society, out of an opportunity to be able to succeed, then we need to take a look at that. And then finally, licensing boards should still have some review, but some are overly restrictive. So maybe the task force could make sure they look at that. Thank you very much. This is a bill for efficiency, fairness, and is much, much needed after 23 years of thinking I'd help fix it. Take care. Thank you.
Thank you.
Callers, if you recently joined and would like to testify in support of Assembly Bill 160, please press star 9 now to take your place in the queue. Again, if you'd like to testify in support of Assembly Bill 160, please press star 9 now.
Good morning, members of the committee. My name is Lilith Barron, Lilithbaran, and I'm the policy manager for the ACLU of Nevada. This automatic sealing of records bill is tremendous, and we would like to offer full support. This will provide individuals with a fair chance to move on from their past mistakes and rebuild their lives without the stigma of a criminal record. By automatically sealing records relating to certain convictions and charges, this bill will ensure that individuals who have paid their debt to society are not unfairly penalized for the rest of their lives. This will not only benefit those individuals, but their families and communities. And these are barriers that perpetuate a cycle of poverty and crime, disproportionately so to marginalized communities. We recently held a record sealing event with the ACLU of Nevada and Clark County, and those folks were overwhelmingly Black women and people who were unhoused and already struggling. So this would be a really important piece of legislation. We'd like to thank the sponsor and the body. Thank you.
Chair, there are no other callers choosing to testify in support at this time.
Thank you, Broadcasting. With that, I will open it up to anyone here in Carson City that would like to testify in opposition of Assembly Bill 160.
Good morning, Chair Miller, members of Judiciary. My name is Beth Schmidt, B-E-T-H-S-C-H-M-I-D-T. I am the Director of Intergovernmental representing the Las Vegas Metropolitan Police Department. We are in opposition to AB 160. We agree with Assemblyman Miller. Record sealing is not easy. It is not simple. Record sealing is extremely labor intensive, and we don't anticipate the human element going away with this bill. In our experience, record sealing is not the process of pressing a button or using one piece of software. Record sealing can take anywhere from hours to days, depending on the complexity of the case and the number of areas that may have records. LVMPD currently seals 1,600 adult records per year. With the implementation of this bill, we anticipate sealing 48,000 adult records per year. The software being proposed would utilize technology to seal the criminal history repository database. LVMPD has approximately 20 different databases and systems that must be queried to ensure a record is properly sealed, and it is important that the record is properly sealed. We believe that if we even started today to make process and technological upgrades, we do not believe that we would meet the implementation deadlines set forth in this bill. Without a complete restructure of how we seal records in Nevada, we believe this approach adds layers on top of an already cumbersome process. And without significant resources, the LVMPD has serious concerns about our ability to effectively seal records in a timely manner as proposed in AB 160. The sealing process encompasses more than just removing the criminal history repository from the database. All of the supporting documentation also needs to be removed from production, and this documentation is spread out over numerous locations and medium. LVMPD staffing would be severely impacted by this process, to include the creation of a new record sealing bureau that would exceed the size of our current record fingerprint bureau. We have been working with Assemblyman Miller, and we look forward to continuing to work with him on AB 160.
Thank you for your testimony, Director Smith.
Good morning, Chair Miller, members of the Assembly Judiciary Committee. Mary Sarah Kinner, Mary-Sarah, last name Kinner, Kinner, on the Washington County Sheriff's Office. We are also opposed to the bill in the current form. We're not opposed to record sealing. However, we have some concerns about the automatic timelines, as well as our ability to come into compliance with the technologies set by the date. We look forward to working with the Assemblyman. I think we have a meeting with him later in the week on this bill as well. Thank you.
Thank you. Is there anyone else here in Carson City that would?
Good morning, Madam Chair, Madam Vice Chair, members of the committee. My name is Zach Bucher. That's Z-A-C-H, B like boy, U-C-H-E-R with the City of Las Vegas. Here today, under the rules of the committee, we have to testify in opposition, not because we're opposed to the end goal of this bill, but we have serious process concerns due to increased workload, staffing, and technological upgrades with no additional funding in this bill to accomplish the outlined objectives. So basically, we're looking at an unfunded mandate. The proposed conceptual amendment addresses much of our concern, and a task force could significantly improve the process for implementing this policy. So we look forward to working with the sponsors and stakeholders to help make it work. Thank you very much, Madam Chair.
Thank you. Anyone else here in Carson City? Not seeing anyone else here in Carson City Broadcasting, can you please open the lines?
If you would like to testify in opposition to Assembly Bill 160, please press star 9 now to take your place in the queue. Again, if you would like to testify in opposition to AB 160, please press star 9 now.
Good morning, Madam Chair and members of Assembly Judiciary. Pam Porto, P-A-M-E-L-A, D-E-L-P-O-R-T-O. I am Executive Director for Nevada Sheriffs and Chiefs Association, and we are testifying in opposition today to Assembly Bill 160. We look for Assemblyman Miller to be able to proceed with this, and for being on the task force, should that, thank you.
Ms. Porto, I'm not sure, or Del Porto, I'm not sure if we caught all of that. So if you can hear us, if you would like to submit your testimony in writing, we would appreciate that, because I'm not sure if we got cut off. Broadcasting, next caller.
Caller with the last 3 digits, 389. You are unmuted and may begin.
Good morning, Chair Miller, members of the Assembly Judiciary Committee. This is Jennifer Noble on behalf of the Nevada District Attorneys Association. In 2017, we worked with then the Majority Leader, now our Attorney General Aaron Ford, on SB 125, and we supported that bill and agreed to shorten the time applicable to violent crimes and by 1/3, and for all other crimes, we cut that time by over half. We also agreed to a presumption in favor of sealing, and the current law reflects good faith negotiation by the prosecutors of this state And we agreed to that with the understanding that each petitioner would still be required to demonstrate rehabilitation and would be given individualized consideration. Believe it or not, DAs do believe in second chances as well, but we appreciate the intent of this bill. But the problem is the automatic process that's contemplated in the conceptual amendment eliminate a petitioner's obligation to provide their criminal history and apply. And they replace important required information with a haphazard system of names and convictions. And I want to make clear to you that once a record is sealed, DAs cannot see it. So if a person reoffends, we will not know about their prior criminal history. Currently, we struggle to conduct evaluations of sealing applications that we receive. Faced with the overwhelmingly large list of only names and convictions, it will be impossible with our existing resources to run these individuals in the local and national criminal history databases to verify they haven't reoffended during the waiting period in Nevada or somewhere else. DAs do not have the personnel or the infrastructure required to conduct meaningful review of the lists contemplated by the bill, and no provision provides us with any additional resources. Even if we were able to run the criminal histories, there are not enough prosecutors to review them, so our ability to object will be rendered effectively meaningless. Although the bill's effective date has been pushed forward, extra time simply does not equal extra resources. Hearings that should be occurring will not occur, and we believe that victims and the people of Nevada deserve consideration as well. Thank you.
Callers, if you've recently joined and would like to testify in opposition to Assembly Bill 160, please press star 9 now. Chair, there are no other callers choosing to testify at this time.
Thank you, Broadcasting. With that, I'd like to open it up to anyone who wishes to testify in neutral of Assembly Bill 160.
Morning, Madam Chair, members of the committee. A.J. Delap on behalf of the 8th Judicial District Court. We're here neutral on the measure. We understand this is a policy committee. However, we're just highlighting the fact that there is a substantial fiscal note on this measure that we'd like to draw the attention of the committee to. And we'll be
we don't discuss fiscal notes in the committee, but
I appreciate
please
that.
proceed. Yes.
And that will be the end of my testimony based with that admission. So thank you, ma'am.
Thank you so much, but we will still put you on for neutral. Thank you.
Good morning, Madam Chair, members of the committee. Alicia Lerud, L-E-R-U-D, from the 2nd Judicial District Court. We are here testifying in neutral today on this measure. My prepared remarks that I came with this morning were largely just to highlight the fact that right now the sealing process within Nevada is anything but automatic for those of us working on the back end of it. That it is a labor-intensive process for both the courts and all of the different agencies that are involved in the criminal justice system. I believe that the conceptual amendment that has been presented this morning highlights that, and I thank Assemblyman Miller and Ms. Kennedy for bringing that conceptual amendment forward, because it is a very arduous process. Just to put into context what this bill means for a workload, and again, I'm with the 2nd Judicial District Court in Washoe County. We deal only with gross misdemeanor and felony offenses. Over the last 10 years, we've averaged about 105 petitions to seal that are brought via petition. We estimate that this will increase that workload by about tenfold, and that will require all of those cases to be reviewed, even if we do figure out system automation. When a case is sealed, it still has to go to a judge for an order. That order still has to be processed. The judge still needs to review that order. And then the court, under this bill and under current process, is responsible for notifying all involved agencies. Right now, our list of agencies that we notify on automatic sealing is at 12. So we have to prepare letters, copies of those orders to go out to those 12 other agencies, and that's the court's workload. One other item within this bill that we would like to highlight is that My understanding is even with the conceptual amendment is that the court would be prohibited from holding a hearing if there was not a prosecutorial objection. And judges would certainly like to still be able to fulfill their obligations and review these to ensure that cases that are put forward for sealing have met the requirements. Thank you.
Thank you.
Thank you, Madam Chair, members of the committee. For the record, Mike Cathcart, Mikecathcart, representing the city of Henderson. And I hope, Madam Chair, that you would indulge us. We have one of our attorneys from our city attorney's office on the line, and he was trying to get in under a pose. He is on now, and we were hopeful you would let him still testify.
Okay, I will go back to broadcasting in a moment. We're going back, yes. Thank you. Is there anyone else here in Carson City that would like to testify in neutral? Okay, with that, I will open it up to broadcasting. Please open the line. I'm not sure which order the city attorney is in, but please, it is open right now for anyone testifying in neutral with the one exception.
Callers, if you would like to testify in neutral for Assembly Bill 160, please press star 9 now to take your place in the queue.
Good morning. Cyrus, C-Y-R-U-S, H-O-J-J-A-T-Y. Thank you for bringing this bill. I like to give people second chances. However, I'm just concerned about the long processes that it's going to take. Thank you.
Thank you.
Thank you, Chair Miller, members of the Judiciary Committee. This is Mark Schifalaqua, SCHIFALACQUA. They didn't have a conference room down at Grand Sawyer, so thank you so much. I am logging on a little bit late today. I am the head of the Criminal Division for the Henderson City Attorney's Office, and although I'm speaking in opposition of AB 160, wanted to thank Assemblyman C.H. Miller for the time he gave us. While it's true that 10 other states have enacted limited automatic record sealing laws, AB 160 would represent, in my review of these laws, the most expansive criminal record sealing law in the nation. Every other automatic record sealing law that's initiated by the state or by a central court system is not as expansive as AB 160. In other states like California or Virginia, it allows for acquittals or when charges aren't filed. In Utah, maybe low-level nonviolent convictions, but never domestic violence or DUI. In New Jersey, some drug offenses. Some states put caps on the number that are eligible, like Michigan, only 4 misdemeanors. If you have 30 or something like that, you got to file a petition and show it in front of a court. All of these other states extend the wait times for automatic sealing. They're all between 5 and 10 years. And some states like North Carolina only allow it to occur once, a one-time act of grace. AB 160 doesn't cap the number of convictions, doesn't allow it one time per defendant, doesn't limit it to nonviolent offenses, and doesn't extend the waiting period. So we have some assurances that the defendant has truly changed his or her life around. Also, this appears retroactive, so it would be all cases from the beginning of time. This essentially is a process change, but it's really policy. It would overwhelm the system. I have about 250 cases for sealing a year. This would be about several thousand a year. There wouldn't be meaningful review or checks and balances, and it would overwhelm the system. This is further than any other state law in the nation. So without some extra safeguards and limitations, we would be in opposition. And I do want to thank the grace you gave me to chime in a little bit late with the problems we were having this morning. Thank you, Chair.
Thank you. Broadcasting, is there anyone else on the line for neutral?
Callers, if you'd like to testify in neutral for Assembly Bill 160, please press star 9 now. Chair, there are no other callers choosing to testify in neutral at this time.
Thank you. With that, I will close testimony and welcome Assemblyman Miller back up for his final remarks.
Thank you, Chair. I just have one final thing to say. I want to thank you all for the time, but we've heard multiple agencies mention how many records they seal now versus how many records they would be sealing. And I think one of the estimates was from around about 1,000 a year to 48,000 a year. How exciting is it that we have an opportunity as a body to give that many more Nevadans a second chance at life, a fresh start? I urge you to support this bill and do the work of government for the people of Nevada. This is what we're here to do. Thank you.
Thank you, Ashley Kennedy, Clark County. I just wanted to put a few technical clarifications on the record. One in regard to NRS 179.295, which relates to the reopening or the of sealed records for inspection. And I want to note that there is that in the event, for example, that an arrest record was sealed because there was the prosecution declined to press any charges, the prosecution still later can file charges before the statute of limitation runs out, and the court can order the inspection of sealed records. There's also a situation in which if someone was arrested but their charges were dismissed and an arrest record was sealed, the court may allow the inspection of records by a prosecuting attorney upon showing newly discovered evidence that the person has been arrested for the same or a similar offense, and there's sufficient evidence that that person will stand trial for the offense. I want to put that on the record to make it clear that there is still circumstances in current law in which sealed records can be inspected for the sake of public safety. And then in regards to the financial aspect, I know this is not the money committee, and there's some more work to be had. You also sit on Ways and Means, so expert here. But I wanted to make a note about the federal funding that is available for things like this. The National Criminal History Improvement Program, which has existed since 1995, lives within the Department of Justice, and they work to award states competitive grants for technical assistance to improve the quality, timeliness, and accessibility of criminal records. Just last year, they allocated $200 million over the next 5 years for states to improve their criminal history reporting. And one of the allowable uses is automatic record sealing. So I want to say that there is federal support out there for a policy such as this. And that concludes my remarks. Thank you.
Thank you so much. And with that, I will go ahead and close the hearing on Assembly Bill 160. Our next bill on the agenda is Assembly Bill 170. Assembly Bill 170 revises provisions relating to certain offenses involving concentrated cannabis. Give the room a moment to transition so that our bill presenters can make it up. Assembly Bill 170 is sponsored by Assemblywoman Monroe Moreno and will be presented by Assemblywoman Monroe Moreno and Miss Erica Roth. And so give you a few minutes to get settled. When you're ready, please proceed. Excuse me one moment. Can we have someone shut the door, please? Thank you.
Wow, there's not as many people for my bill.
You sure can clear a room.
Thank you, Chair Miller and the members of the Judiciary Committee. I am Assemblywoman Danielle Monroe Moreno, and I proudly represent Assembly District 1. I'm here today to introduce Assembly Bill 170. This bill closes a loophole from a bill I sponsored last session, Assembly Bill 158. And I will remind this body that that bill passed through both houses of this legislature unanimously. Just a little background. Assembly Bill 158 of the 81st legislative session established and revised the penalties for certain misdemeanor offenses involving marijuana and cannabis. Instead of imposing a punishment of imprisonment in the county jail, imposing a fine, or imposing both a fine and imprisonment for these offenses, the bill required an adult convicted of illegal possession of 1 ounce or less of marijuana to perform community service attend a victim impact panel, or undergo a program of treatment, or any of the combinations of above. The bill also expanded the jurisdiction of juvenile courts to include offenses committed by children relating to possessing 1 ounce or less of marijuana. The measure provided that the first and second offenses result in the juvenile offender being deemed a child in need of supervision rather than a delinquent child. The intent of AB 158 was to revise the penalties applicable to the illegal possession of marijuana. However, because of the way our statutes are written, concentrated cannabis is not included in the definition of marijuana. Therefore, the illegal possession of concentrated cannabis by a person under 21 years of age or by an adult who is 21 years of age or older is a Category E felony, and this creates a large discrepancy in our law. Assembly Bill 170 standardizes the penalties for the possession of 1/8 of an ounce or less of concentrated cannabis by making them the same as the penalties for possession of 1 ounce or less of marijuana, thereby getting rid of the discrepancy in law and closing the loophole from last legislative session's bill. Joining me here today is Attorney Erica Roth with the Washoe County Public Defender's Office to explain the reasons why we're here today and also to explain to you how this loophole has directly affected a number of children in our community. She will walk you through the bill and the amendments. So, Madam Chair, with your permission, I will turn it over.
Thank you, Madam Chair, members of the committee. My name is Erica Roth, ERICAROTH, on behalf of the Washoe County Public Defender's Office. I want to first thank the sponsor of this bill and highlight the issue that we have seen in Washoe County. This isn't a statewide issue, and that's important for this body to understand. The law in this state is not being applied equally. In Washoe County, and as I provided, in the last year we pulled data with a total of 280 cases that the Washoe County Public Defender's Office represented clients on in the last year. 70.36% of those were for possession of marijuana, specifically for possession of concentrated cannabis. So we have to ask why in this state is that happening? The law, as previously set out, defined marijuana, it did not define marijuana. However, marijuana is defined in other statutes, and that's simply what we're doing here in this, in AB 170, is we're establishing a uniform definition of marijuana, which includes concentrated cannabis, and that's because that's always been the intent, right? A child who is found with a vape pen, for example, at a high school in in Reno, is now being charged with a felony offense. So when we do a breakdown of the demographics, and I provided, this was the raw data that was provided to the committee, but the population in Washoe County of total population is 61.1% white. When we're looking at who we're representing, it's only 36.04% white clients who are charged with possession of marijuana. The total population of Hispanics in Washoe County is 25.3%. The total population of our clients, is 25.3%. The total population of our clients is 32.49%. When we look at the black population in Washoe County, it's 6.60%. The population of our clients is 6.60%, and it's much less than that in Washoe County. So this is important to understand when we're looking at why closing this loophole is so important and how it's impacting our clients. We recognized last session that ensuring that juveniles are treated differently than adults is the first step in addressing the prison to the school to prison pipeline, which is a long-lasting negative consequences that includes difficulty finding employment, denial of educational opportunities, discrimination in housing and services, and later incarceration as adults. This bill will clean up the misplaced argument that juveniles should be prosecuted as felons for possession of marijuana in any form. When looking at the amendments, you'll see it's a very simple change. In the digest, it states that sections 1 through 4 of this bill conform the specified sections of this NRS to the definitions of marijuana and concentrated cannabis as prescribed in NRS 678A.085, And that will point you to NRS 453.096, which defines marijuana to include all parts of any plant of the genus cannabis, whether growing or not, the seeds thereof, the resin extracted from any part of the plant, including concentrated cannabis, and every compound, manufacture, salt, derivative, mixture, or preparation of the plant, its seed, or resin. So this is important as what we're doing is pointing to the definition of marijuana as it already exists in law. As it exists in law, the definition of marijuana includes concentrated cannabis. And there's no reason that we should be situating juveniles separately in one single county in the state of Nevada for the possession of concentrated cannabis, which is defined as marijuana already under law. When talking to juvenile services in Washoe County, these cases, possession of marijuana for concentrated cannabis specifically, is the number one referral in the county at this time. The amount of resources that are being spent prosecuting these cases is astronomical, although unknown. I can't tell you that number at this time, but it is the number one kind of case that is being referred. That means not only that a child is now facing potentially a felony conviction, but it also means that their parent has to take the day off of work to come to our office to meet with our attorneys to determine what's the appropriate steps. They have to take additional time off of work to go to court with that child, to help them with the services that may be required additionally and beyond what we would normally expect from this kind of case. Brian Stevenson once said that we've become so fearful and vengeful that we've thrown away children, discarded the disabled, and sanctioned the imprisonment of the sick and the weak, not because they are a threat to public safety or beyond rehabilitation, but because we think it makes us seem tough and less broken. The law was made clear last session. We should not be charging juveniles with felony possession of marijuana. They're not similarly situated, and we recognize that they deserve resources and punishment that falls outside of the criminal legal system. By defining in this bill, a cleanup bill, the definition of marijuana as it already exists in law to include concentrated cannabis, we make clear to each district attorney in each county of this state that juveniles should not be facing felony charges when they show up to school with a vape pen with some amount of marijuana in them. And with that, I'll turn it back to our Assemblywoman. Thank you.
Thank you. Danielle Monroe Moreno for the record. During the interim, I received calls from parents throughout the state. As you've heard from testimony, there's only one county that we're having this problem with. I've had calls from parents saying, hey, I thought you passed a bill that my kid, if they got caught with a little bit of marijuana, wasn't going to get a felony. And I said, hold on, there is a law in place. But parents were so eager to get their kid out of jail that they were taking plea deals, giving their kids these records that are going to follow them for the rest of their lives. And in talking with attorneys in Clark County and in Washoe County, there was a loophole that we needed to clean up. So that if an officer, and sometimes there's a few officers that are a little heavier with who they arrest than others, making sure that the law was clear, making sure that mom and dad that may have a kid that might have marijuana where they probably should not have the marijuana, or might have a cannabis oil and a vape pipe, and they probably shouldn't have that. There's other ways to go about teaching that child right and wrong, And it's not a felony arrest, a felony conviction that will follow that child for the remainder of their lives. And me, as a black mama who has black and brown children, the majority of those children were black and brown. So I'm coming before this body again and saying, help me fix a loophole in a bill that we all passed unanimously from this body last legislative session. And we'll stand for questions.
Thank you, Assemblywoman Ms. Roth, for your presentation and for bringing this bill forward. With that, I will open it up to questions. Our first question is from Vice Chair Marzola.
Thank you, Chair, and thank you so much for bringing this bill and closing this loophole. As a mother of a black son who lives in Reno, I appreciate this cleanup. My question is this: from the stats that you two provided, it does affect black and brown children. Is this an issue with the entire police force in Washoe? Are we talking about just a couple of officers? Are you able to answer that?
Erica Roth for the record. Yes, with the data that we pulled, and this is not exhaustive data, I was able to pull data for a period of 1 year, and I think that as we continue moving forward, we would be able to pull more data. I can tell you that this came back to, almost all of these cases came back to 4 officers.
Follow-up, Chair.
Yes, please.
And has this issue been addressed with the 4 officers? And if you could provide name on the record, that would be wonderful.
I can, if I can have one moment. Erica Roth for the record, and thank you for that question. With our analysis, we were able to pull back the majority of these cases to, it was 3 officers. So 50 of the 197 cases were, and I'm sorry, I'm not sure of their title, whether that's deputy, sergeant. 48 of the 197 cases came back to, and 31 of the 197 cases came back. We have 68 cases of that 197 in the other category, and so those just aren't determined at this time of the arresting officer.
Proceed.
Thank you. And my last question is, have they been reported? Is there anything happening as far as what they're doing out in our streets with our kids?
Erica Roth for the record, and thank you again for that question. I can't speak to whether they've been reported, but what I can speak to is where our challenges have come in litigating these cases to try to deal with this issue outside the legislature. To us, when we read this, it's very clear that these children should not be prosecuted for felony offenses. But what's highlighted in this process is how unjust the system can often operate. And so a child will be charged with the felony. It's incredibly scary for a child to realize that they now may be facing a felony conviction. And we, as attorneys, we need standing and permission from our clients to litigate a case, to raise certain challenges. And we can't do that when they are on the eve of trials, eventually offered a plea negotiation for misdemeanors that they want to take. And so it leaves our office in a position where we have been unable to really litigate these cases and bring them before the Supreme Court. But all these resources are being used up until that point. And it also begs the question of why. If ultimately they are going to resolve as misdemeanors, why are they being brought as felonies? Why are we dragging children through the mud, facing felony convictions, traumatizing them with this threat at this time?
Thank you so much. Thank you, Chair.
Thank you,
Madam
Vice Chair. Yes, please.
Just a comment. My career was in law enforcement, almost 30 years, right? I have respect for our law enforcement officers. Every day when we put on that uniform, we're putting our lives on the line to protect the community around us. And oftentimes, we're all human, right? And sometimes the interpretation of a law by an individual is what gets us to this point and what's gotten us to Assembly Bill 170. And it's making sure that it's taking away that interpretation of the law, but making sure that it's clear that every officer is able to understand and enforce the law as it was intended.
Thank you for that, and I appreciate that comment as well, because I wish that many different professional fields would ensure better communication with employees and professionals in the deliverance of new legislation that's passed here. And so I think that's a very fair assessment. Thank you for that. With that, we have a question from Assemblyman Ordlicker.
Thank you, Chair, and thank you for bringing this bill, which I like because I'm co-sponsoring. But I just have one question. In the change with the amendment, I understand why you'd want to just conform it to existing definitions, but I notice it changes the level of when this is triggered, because in the original there was 1 ounce of marijuana versus 1/8 ounce of concentrated cannabis, and it looks like with the change now it's 1 ounce for both, and maybe that makes sense. Was it wrong before to say concentrated cannabis should be at a different amount? Am I reading that correctly?
Erica Roth for the record. That is correct. This change simply defines what concentrated cannabis is, and I think it's a two-part answer to this. One, it's important to understand that concentrated cannabis was not excluded. The intent last session was to ensure that a juvenile, and I also want to make clear that some of our clients are as young as 12 years old in some of these cases that we pulled. So these are 12-year-olds facing potential felony convictions. But when you break down section 1 and 2 in the bill, concentrated cannabis was only defined for adults by weight, and that's because traditionally we recognize that adults and juveniles are not similarly situated and should be treated differently within the criminal legal system. And so I think this reflects the original intent by simply saying that concentrated cannabis is marijuana as defined by law and should be treated different, and should fall under section 2 of this statute.
All right, I don't see any more questions from members. Assemblyman, proceed.
Sorry, Chair, I was just trying to type it in. Thank you. I appreciate the opportunity to ask this question. By the way, I get the challenge that's going on here, and I appreciate you coming into my office and talking to me about this as well, and think that this is a loophole that would be worthwhile to close. While I don't think the intention here this morning would have been to demonize our law enforcement officers, I don't think you were trying to do that at all. My concern as a prior law enforcement officer is that it could be interpreted that way. And so when we talk about a disproportionate number of police officers in Washoe County that might have been at least perceived to be overcharging these kids to get plea deals or whatever, that there might be another explanation for that. And so just to kind of help get it on the record, to ensure that, certainly if there's problems, I, by the way, believe in holding our law enforcement accountable. Do we know if those individual deputies or officers were assigned to task forces that deal with this, or were they assigned to schools where they had a higher level of interaction with children, where they had increased opportunities or chances to even charge juveniles with this? That there might be some other explanation. Thank you.
Erica Roth for the record, and thank you for that question and that comment. And I agree, neither the sponsor and I came up here to demonize anyone. This is a real problem that's having real consequences. Those officers, to my understanding, are assigned to schools. And so I agree, there is a reason, right, that this is not the 4 officers in the entire, agency that are just targeting kids. They are assigned to schools. But it does ultimately come back to a very small portion of officers. But it's not simply, and this is not to demonize those specific officers. This is a county-wide problem. There are many people in the line who have are in power who can say at what point does this stop, right? And so it does not simply fall on the back of those single officers, right? And so I agree with that, and I appreciate that comment.
Thank you so much. With that, I will go ahead and open it up for testimony. So anyone that would like to testify in support of Assembly Bill 170? Again, asking that you keep your comments brief.
Thank you again, Chair and Committee, and also Assemblywoman Monroe Marino. It's incredibly exasperating to have to clarify that we don't want young people to go to jail for marijuana. This is the second time that I personally am here to talk about how we don't want young people to go to jail for marijuana. I'm here on behalf of the NAACP of Las Vegas, Nevada, and also Cannabis Equity and Inclusion Community. I want to I get emotional because I just feel like I'm consistently chasing down the criminalization of marijuana. Every single time we think that we have stopped people from going to jail, there's another way that shows up that we are putting people in jail. Yet, there are people making millions of dollars, spending millions of dollars to sue people for millions of dollars to make money off of this product. But we continue to find ways to criminalize this product. It is no longer a drug. It is a product. They are making money. It has been legalized. You can go into the stores and purchase it. I have young people that come into my office consistently talking about how come they don't have an opportunity yet they're still trying to put them in jail. Just recently, I had a young man, craziest thing, that they're still doing stings to find people that are selling marijuana. Why? The police can go to the store and purchase it. That is a joke. I just want to impress on this committee that the legislators passed this unanimously last session. And I am hurt for my families, and I say it's my family because it's not just my community. I have family in Washoe. I have nieces and nephews in Washoe, just as well as I have them in Clark County. I do not want to continue to spend time to come up here to ask the legislators to stop criminalizing people for a product that people are making millions of dollars off of. I am hurt. I am hurt for those families. I am hurt for those families who had to take plea deals because they thought they were protecting their children. Can you imagine having to choose between your future, your child's future, the idea that you have for them, and this plea deal because you think that's the only way that they're gonna have a life? It's not fair, and I'm over it. And I'm asking the committee to please consider that this bill is relevant and important enough to pass. Thank you. And
Thank you, Ms. Goins.
Good morning, Chair and members of the committee. We are here in for the record, my name is Annette Magnus, and I'm the Executive Director of Battleborn Progress. We are here in strong support of AB 170. We believe this important cleanup bill is critical. Our young people should not be subjected to felonies for doing something that others are not being criminalized for. We should want less young people in our criminal justice system, not more. The fact that young people in Washoe County are being charged with something that will impact them for years to come is wrong. This bill is actually very personal to us at Battleborn Progress. One of our staff members has had this happen to their child in Washoe County a few months ago. She will be testifying by phone later. Days off work and stress about their child's future has now become the reality that they are dealing with weekly. And in our attempt to support our employee, we have seen the aftermath that this has caused. As an employer, it has been horrifying to watch how her child has been treated during this process. We need to clean up our laws and make them consistent and uniform across the state. Please pass this important legislation. Thank you.
Thank you, Madam Chair. John Piro for the record, John-Piro from the Clark County Public Defender's Office. I want to thank Assemblywoman Danielle Monroe Moreno for, again, keeping the commitment to this process. Last session, we thought the bill was clear, but there's this quote attributed to Justice Scalia that legislative history is like looking over a sea of your friends and just picking out the ones that you like. So now we're just going to make the text even more clear so that a loophole is not exploited anymore. One of the reasons people don't like lawyers is sometimes we exploit loopholes. So let's close this loophole and move forward by treating kids like kids, getting them the rehabilitation they need without putting a felony on their record. Thank you.
Thank you, Chair Miller and committee members. My name is Nick Shepak, S-H-E-P-A-C-K. I'm the State Deputy Director of the Fines and Fees Justice Center. However, today I am here testifying as myself. Last session, I had the immense joy of being able to work on this bill with the Assemblywoman, and in the many stakeholder meetings we had, there was no inclination at any point that we did not intend to capture all types of cannabis. That was never mentioned once. I was in many, many stakeholder meetings, and I want to get that on the record. I think that's abundantly clear by the fact that every county except one is following the original intent of the law. I think that's clear. Just for edification, from our position, we were looking at it similar to alcohol. You don't charge somebody who has Paps at 3.5% alcohol differently than somebody who has a bottle of wine than a child who has a bottle of booze, right? It is our job to determine the help that each individual needs, but these things should be viewed the same in law. That was the intent. That was the intent in every conversation we had, and we're happy to see you willing to close this loophole. Thank you very much.
Good morning, Chair Miller and the Assembly Committee on Judiciary. I am Chris Reese, it's R-I-E-S, representing the Las Vegas Metropolitan Police Department. We support AB 170 and feel that it clears up some confusion when it comes to concentrated cannabis. We feel that a person under the age of 21 possessing less than 1/8 of an ounce of concentrated cannabis being a misdemeanor is appropriate. We thank the bill sponsor, Assemblywoman Monroe Moreno, and we support this bill. Thank you.
Good morning, Chair and members of the Judiciary Committee. My name is Carly Hand, K-A-R-L-Y-H-A-N-D for the record, and I am an intern with the Washoe County Public Defender's Office. I am in here in strong support of Assembly Bill 170. I would like to echo the sentiments of those who testified before me. This bill will eliminate a loophole that is disproportionately affecting juveniles, particularly juveniles from minority populations. It is crucial to protect these children as young as 12 years old who are facing felony charges in Washoe County. Therefore, I strongly urge you to unanimously pass AB 170. Thank you for your consideration.
Is there anyone else here in Carson City that would like to testify in support?
Jonathan Norman, N-O-R-M-A-N, with the Coalition of Legal Service Providers. We represented at any given time between 3,000 and 4,000 kids in foster care. And in Clark County and in Washoe, I believe both counties have a dual jurisdiction calendar for kids who have DJJS involvement as well as in child welfare. And we support this measure. We should be treating kids like they're kids, and any criminal justice thing that kids can be charged with falls disproportionately on foster kids. So thank you, and we support this bill.
Thank you for those testimonies. Not seeing anyone else here in Carson City. Broadcasting, will you please open the line?
Callers, if you'd like to testify in support of Assembly Bill 170, please press *9 now to take your place in the queue. Again, if you'd like to testify in support of Assembly Bill 170, please press *9 now.
Good morning. Jim Hoffman, representing Nevada Attorneys for Criminal Justice. Vaping is not good for your health. Kids should not be vaping. They should not be using weed. But at the same time, we don't think it makes sense for that to be a felony. We believe that the existing statutory framework is a good one, got unanimous support. We would ask that concentrated cannabis cartridges be placed under that same framework. Thank you.
Hello, Chair and members of the committee. For the record, my name is Amber Falgo. That is spelled AMBER FALGOUT. I am the Northern Nevada Manager with Battleborn Progress, but I am testifying in my personal capacity today. I am a resident of Assembly District 25. I am here to testify in support of Assembly Bill 170. My family has a long history of substance abuse. My husband, in fact, was arrested at 12 years old and charged with felony possession and intent to distribute marijuana. Though he had no controlled substances on his person, a peer had accused him of providing marijuana. He went through a lengthy legal process. Fast forward to 2021, my oldest child was arrested for felony possession after she was found with a marijuana vape pen. Both of these incidents were around marijuana, which is now legal in Nevada. Drug possession should not be an automatic felony. This is simply another archaic tool used in the drug war to punish communities of color and others who do the same thing that various people around me do legally. Never once have I seen someone get clean or stop using simply because they were arrested. Often these charges lead to felony convictions which further disenfranchise people and make it more difficult for them economically, socially, and emotionally. Please pass AB 170 so we can begin to turn the corner and start finding solutions to drug possession and abuse that actually work. Thank you.
Hello, my name is Elizabeth Flores, Elizabeth, Flores, Florez, Z as in zebra, and I'm the Director of the Washoe County Department of Juvenile Services, and we are calling in support of AB 170. It was noted earlier in testimony that possession of a controlled substance has grown to be the #1 referral to juvenile services in Washoe County. In fact, possession of concentrated cannabis to our agency has more than doubled in numbers from 2021 to 2022. I must, however, correct earlier testimony provided by Ms. Erica Ross naming 3 officers for bringing forward felony charges for concentrated cannabis. These individuals are juvenile probation officers who are assigned to our probation assessment unit and whose function is to assess all referred felonies, which are required by law to be forwarded to the Washoe County District Attorney's Office. Our juvenile probation officers are not the primary agents of arrest. We receive these referrals from local law enforcement agencies and must process them as required by law. The vast majority of these referrals come from the Washoe County School District Police Department. In reviewing the profile of these youth in Washoe County, over 60% of these youth were first-time offenders assessed as low risk to reoffend with low substance abuse treatment needs. The passage of this bill would allow this population of youth the benefit of court diversion and would reduce costs associated with formal court proceedings, which require the time of the district attorney, public defender, and family court. If concentrated cannabis is reduced to a status offense, juvenile justice agencies remain positioned in law through NRS 62C200 to continue to hold youth accountable and provide proper assessment and therapeutic services to this population with no evidence of negative impact to public safety. Thank you.
Ma'am?
Yes.
Thank you. I just want to clarify, you're still in support of the bill?
I am still in support of the bill. I just wanted to correct earlier testimony.
Okay, thank you for that. Next caller, please.
Callers, if you had recently joined and would like to testify in support of Assembly Bill 170, please press *9 now or press raise hand in your Zoom window to take your place in the queue.
Marcos Lopez, Nevada Policy, MARCOS LOPEZ. We're in support of SB 170 for many of the reasons that the previous testifiers in support mentioned. Generally, prohibition is a bad use of tax dollars. It never really realizes what its promises. And in fact, we would encourage the committee to go further and also revisit the amount that individuals can possess overall. Thank you.
Chair, there are no other callers choosing to participate at this time.
Thank you, Broadcasting. With that, I will go ahead and open it up for testimony in opposition of Assembly Bill 170. If there's anyone here in Carson City that would like to testify? Not seeing anyone? Broadcasting, would you open the lines, please, for anyone in opposition?
Callers, if you would like to testify in opposition to Assembly Bill 170, please press star 9 now to take your place in the queue. Again, if you would like to testify in opposition to Assembly Bill 170, please press star 9 now. Chair, there are no callers choosing to testify at this time.
Thank you. I would like to open it up for anyone wishing to testify in neutral of Assembly Bill 170. If there's anyone here in Carson City that would like to approach? Not seeing anyone? Broadcasting, is there anyone on the phone lines?
Callers, if you would like to testify in neutral for Assembly Bill 170, please press star 9 now to take your place in the queue. Again, if you'd like to testify in neutral on Assembly Bill 170, press star 9 now. Chair, there are no callers choosing to testify at this time.
Okay, thank you for that. I would like to welcome Assemblywoman Monroe Moreno back up for any final comments.
Thank you, Madam Chair. Danielle Monroe Moreno, for the record, I'm going to let Ms. Roth make a statement, then I'll make my final words.
Thank you, Chair Erica Roth, for the record, and thank you to the committee and everyone who testified. I just wanted to make a clarifying statement and ensure that personally apologize to the officers whose names were read. It was not my intention. Those names were handed to me, quite frankly, and we always strive to ensure that the right information is getting out. We appreciate all the services from all of the officers from juvenile services, and so I just wanted to make that clear. But I think it gets really to the heart of this issue is that we all just need a very clear definition of what cannabis is so that there is not this confusion anymore, right? And so I appreciate deeply the Assemblywoman Monroe Moreno for bringing this to ensure that Washoe County, kids in Washoe County are being treated the same as kids across the state, and that's really what we're trying for. I know that's what our office is trying for. I know that that's what those probation officers are trying for in juvenile services, and so I appreciate that. Thank you.
And thank you, Chair Miller and committee, for hearing the presentation of AB 170. I think we can all agree that our kids should be kids, and oftentimes kids make mistakes. We were all kids at one time, and we made some mistakes that we hope wouldn't follow us for the rest of our lives. And today we have an opportunity to fix a loophole in a law that we all passed so that our kids can still remain kids and not let some of those stupid mistakes, decisions that they make, follow them until adulthood. Thank you, and I hope that we've earned your support for this legislation.
Thank you so much for that. And with that, I will go ahead and close the hearing on Assembly Bill 170. The last bill on our agenda for today, giving everyone some moments of transition. The last bill on our agenda today is Assembly Bill 227. Assembly Bill 227 revises provisions related to domestic relations. It is being presented by Assemblywoman Leslie Cohen, Jonathan Norman from Legal Aid, and Stephanie McDonald, who I believe is on Zoom. Ms. McDonald, are you there? Oh.
I'm here with you. Thank you.
Thank you so much for that. Okay, so Assemblywoman, whenever you are all ready, please proceed.
Thank you, Chair, Vice Chair, and Committee. So even less people for domestic relations. But this is a real kitchen table issue for our constituents. AB 227 is about having better, easier, less adversarial ways for our constituents to move their cases through family court in our jurisdictions that have family court, and then in regular court where they don't have family court. So with me in presenting the bill in Clark County is Jonathan Norman, who represents the Nevada Coalition of Legal Services, legal service providers, including Legal Aid Center of Southern Nevada. And Jonathan works as a legal aid attorney, or worked as a legal aid attorney on the Navajo Nation, previously right out of law school. In 2017, he moved to Las Vegas and took a position representing foster children with the Children's Attorney Project at Legal Aid Center of Southern Nevada, and eventually became the lead attorney at Legal Aid's education advocacy team before moving into policy full-time. And then joining us virtually is Stephanie McDonald, who is the Legal Aid Center's directing attorney at the Family Law Self-Help Center, where she's been since 2013. And in this position, she oversees operations at the Family Court Self-Help Center, providing information, forms, and procedural guidance to self-help represented litigants navigating family court. She's also worked as a law clerk in family court for the late Honorable Matthew Harder and the Honorable Sandra Pomerantz. So with that, I will turn this over to Ms. McDonald and Mr. Norman.
Thank you, Chair Miller, members of the committee. My name is Jonathan Norman, N-O-R-M-A-N, and as Assemblywoman Cohen said, I'm with the Policy Director for the Nevada Coalition of Legal Service Providers. It includes Legal Aid Center, Northern Nevada Legal Aid, VARN, and the Senior Law Program in Clark County. The Legal Aid Center of Southern Nevada operates the Family Law Self-Help Center, and we also operate the Civil Law Self-Help Center. Both of those are like legal emergency rooms, whether it's a landlord-tenant issue at the Civil Law Self-Help Center or a family matter at the Family Law Self-Help Center. It's where folks can go to get the right form and to get on the path to resolving or making progress on their legal issue. The Family Law Self-Help Center assists with issues ranging from adult guardianship to child custody, and assists around 80,000 residents of Clark County every year. In addition, it gets about well over 1 million unique users log on to the website to get forms and to access information. So Ms. McDonald runs a significant operation for people in Clark County. If you go to the Family Law Self-Help Center's website, there are a host of forms and how-tos. Under divorce, there is a link to file your divorce together. The link takes you to the forms and steps you need to file a joint petition for divorce. This is ideal for people getting along enough to know they shouldn't be married. Nevada law does not have similar laws for legal separation, annulment, and child custody, which means people have to file a petition and serve their wife, husband, co-parent, and go through what can be an artificially adversarial process, which could become adversarial if someone is served with a petition. It ramps up the emotions involved in obviously emotional issues. So I'm going to turn it over to Stephanie McDonald to walk through kind of the boots on the ground and how this bill will operate. I do want to point out we do have an amendment, and if it's okay with the chair, we would work off of the amendment.
Yes, please.
And then I did also speak with Victoria Kuba and Kim Surratt, I may have their names wrong, with the Nevada Justice Association. They're still digesting the amendment, so there may be some additional language, but I think they agree with the thrust of what we're trying to accomplish. They just want to make sure that there are no unintended consequences for family law practititioners, which we certainly appreciate. Our goal is to have forms for pro se litigants, self-represented people to as Assemblywoman Cohen said, to access a non-adversarial forms. And with that, I'll turn it over to Stephanie.
Thank you, and good morning, Chair Miller, members of the committee. My name is Stephanie McDonald. I'm here on behalf of the Legal Aid Center of Southern Nevada. I'm pleased to present AB 227 to all of you today. Family court is a place where people unfortunately find themselves a little too often when family crises happen. Divorce, legal separation, child custody matters, and annulments are the primary issues that bring people into family court for resolution. And it's estimated that here in Clark County, roughly 70% of litigants in family court matters are handling their case on their own without the assistance of an attorney, because often they can't afford legal counsel to navigate their family matter when crises erupt. As the directing attorney overseeing all the operations at the Family Law Self-Help Center, I can tell you self-represented litigants are often bewildered by the court process, no matter what it is. As mentioned earlier, my team and I assist almost 80,000 people per year, all struggling to understand the many rules that they must follow to present their case to a judge. One of the simpler processes that we have available is NRS 125.181, which provides a streamlined process for spouses who are in full agreement to all the terms of a divorce. Those spouses can complete a joint petition with their agreement spelled out. They submit the petition with a jointly signed divorce decree for approval. The process encourages cooperation and is hugely popular for spouses who want to fast track their divorce. But right now, divorce is the only family court matter that can be handled in this expedited, mutually agreeable fashion. Litigants who are in agreement to a legal separation, an annulment, or a child custody matter are often shocked to find out that they must file a contested case regardless of their agreement. To get a court order for one of these processes, one person must agree to be the plaintiff and complete a series of forms to put a proposal together for the court. The other person must agree to be a defendant and file separate forms agreeing to the proposal. I can tell you nobody likes to be a defendant, regardless of, it means nothing so much in family court, but the context of being a defendant is never very appetizing to anybody. Finally, both people must complete a final set of forms to present their agreement to the court for approval. The number of steps and forms required to accomplish a stipulated decree for anything other than divorce is pretty overwhelming. AB 227 would make the same expedited divorce process available to those who are in agreement on a legal separation, an annulment, or those who are not married but want to formalize a child custody agreement with the court. The bill itself, the sections run through each of those areas in succession. Sections 2 through 4 would make the joint process available to those filing for separate maintenance. Sections 9 to 13 make some conforming changes within the existing separate maintenance statutes to reference that process as well. Sections 5 through 8 would make the joint petition process available for annulments, and sections 14 through 19 would make the joint petition process available for those filing for child custody. All of the new proposed statutory language that you see in the bill is based on the existing language in NRS 125 that lays out the joint petition process for divorce. So it is not necessarily new, it's just adapted for those other areas of law that it hasn't previously been applicable to. This bill would ultimately allow those already in agreement to get through the court process easier, reduces the amount of court resources that would be needed to file and finalize a case. And ultimately, it helps litigants maintain a cooperative spirit to resolve their issue, rather than introduce adversarial concepts to those who are not at odds with each other. I thank you for your consideration of AB 227. I'm happy to answer any questions that the committee might have.
Thank you for that. Assemblywoman, are you ready for questions? Okay, thank you. Just want to make sure you didn't have any additional comments. We will open it up, beginning with Assemblywoman Newby.
Thank you, Madam Chairwoman. It's more of a statement on page 4 of the bill, section 7, subpoint 3. I just had to giggle last night, the revoking parky. I think it's supposed to be the revoking party. It's correct, and I believe in the other sections. I was curious what a parky was.
It's a term of art.
Thank you. Let's see. Not seeing any other questions, comments, or grammatical errors. We actually, hold on, we do have one more question from Assemblywoman Hardy.
Thank you, Chair. So I agree with you when there are those instances such as annulments and separations, to be able to do this in a joint petition when they're in agreement would definitely help. Also, for the petitioners and also for the court to streamline it, to get these cases through more efficiently. I'm just curious as far as when you're talking about custody arrangements, those can be a little more intricate, emotionally charged and things like that. And specifically in section 16 where you're saying sufficient particularity, which means absolute terms. So that means every detail of your custody arrangement would have to be spelled out. Holidays, weekends, school, all of those things, which in my opinion can be quite cumbersome and maybe a little more involved in that. So I'm just wondering, do you have any numbers as to like the percentage of custody cases that come in that both parties are just in total agreement to what they're proposing and agreeing to?
Jonathan Norman, Norman. I'm going to defer that question to Ms. McDonald in Las Vegas.
Yes, thank you. Stephanie McDonald for the record. The number of people, thank you for that question, Assemblywoman. The number of people who are seeking a agreed upon court order in regard to child custody are probably the fewest of the batch amongst the areas that we're talking about, because often those who are co-parenting successfully continue to co-parent successfully without the assistance of the court. And that is, of course, the ideal. But we do get, not a ton, but I would say probably 10 a month where co-parents are in full agreement to all the terms of what they want to follow. They're getting along right now. And while they are getting along, they see the usefulness of getting their agreement in writing just in case. Everybody knows somebody who's been through something awful at family court, and those who are planners and want to be proactive are very interested in getting their current terms on record, just in case. Hopefully they never have to litigate again, but the best time to get something on record is when you are getting along, and heaven forbid problems arise later. Now at least they've got their original agreement on record as a court order, and it provides greater assistance for judges who then have to navigate the difficulties or disagreements that might come later, because at least they have a starting point of where those parents were originally in agreement on.
Thank you. And I appreciate that answer, because as I said, custody can be quite a confrontational issue at times, and where parents can't agree, that's wonderful. And obviously various sections in here in the bill, it goes through that the parties would have the right before the order is issued, like they could revisit this. Am I understanding that correctly? Like it all has to be submitted to a judge for review before he issues the order. Before that order is issued, they could go back and revisit what they originally agreed to. If you could just kind of walk us through, they submit their agreement, they change their minds, how would that work, as it goes through and goes to a judge? Thank you.
Sure. Thank you for the question. The way that the process would work, the way that it works now for divorce cases, and many of the divorce joint petitions are between parents who share children together as well. So not only are they getting a divorce, but they're also agreeing to custody, child support, visitation, health insurance terms, et cetera. Everything that you would expect from a child custody order is included in that joint petition for divorce. So it would be the same process for parents who are going through a joint petition for custody. They would have to be in complete agreement before even filing the paperwork regarding what will their timeshare be with the children, what will the holiday schedule be, who, if anyone, is going to pay child support, who is going to provide health insurance, how will uncovered medical expenses be paid. All of those things would be included in the agreement. So without 100% agreement on all of those terms, a joint petition process would not be available to them. If there's even one thing that they can't quite get to an agreement on, they're not going to be able to pass go in this case. However, there is a wonderful mediation program that the UNLV Law School offers, which is available and free to the community. It is an amazing referral that I tend to give people when they are 95% agreed and there's just one sticky little issue that they can't quite get to, but perhaps with the assistance of a free mediation service, they probably could get there. So that is a great stopgap to help those litigants who are really, really close, but not quite there. Again, in order to get the joint petition process filed, they would have to reach a complete agreement prior to filing. The court order would ultimately agree or put their agreement into a court order as long as their agreement makes sense and it complies with the law. It makes it easier for judges just to sign and approve them. If for some reason they can't get to an agreement on one or two little things, unfortunately, they're going to be in the process of somebody filing a complaint, somebody filing an answer, and going down the path of litigation. But this is intended for those who aren't going to need to litigate anything because they've already reached their full agreement. If disagreements come up later, they can reopen the case, they can request modifications, they can request enforcement. But again, that's an if for down the road should problems arise later. This is a way to fast track the case and avoid court hearings and delays to get that order in place.
Okay, and thank you for that clarification. I think that really clarified some things for the committee. Next question from Assemblyman Yurick.
Thank you, Chair. I want to build on the concerns I think might be expressed by my colleague, Assemblywoman Hardy. I, by the way, as a practicing attorney, I don't do family law, and I don't envy those that do. I know that system is quite, can be difficult and emotional and is fraught with challenges. So looking for ways to improve and streamline the system, I'm in full agreement with. But when we're dealing with something like child custody issues, I think that it warrants a higher level of scrutiny and concern that when we're dealing with kids, which is why I'm assuming I haven't gone through the whole legislative history to understand the history of why that was previously excluded from the summary process. But it's one thing to read pleadings when they come across a judge's desk, but my understanding in the summary process, there is no hearing on that issue. So there's no way for a judge to actually look at the parties involved and get kind of assurances through, looking at the parties in his physical or her physical presence to evaluate, does this look like everything is on the up and up? So I guess my question is, are there any concerns or are there ways that we can kind of assure the court that when they're signing off on a summary divorce where there are child custody issues, that in fact what we're getting written on paper and pleadings is truly the intent and the wishes of the parties without undue duress or coercion?
Sure, and I'm happy to take that question. Thank you, Assemblyman. Although this process is designed to be streamlined without a hearing, approval based on an understandable agreement between the parties, Judges always reserve the right to request a hearing if they see something in the paperwork that doesn't quite make sense or looks a little off to them. And it does happen within the joint petition for divorce process. For instance, if two spouses complete a joint petition for divorce that would grant one person sole legal custody, sole physical custody, no visitation to the other parent, that other parent is also not paying child support. If there's something that looks like a complete imbalance of power or something that just doesn't look like the typical kind of order a judge would want to craft, they always have the right to request that the parties set a hearing so that the judge can ask some clarification questions before approving the final order. And there may be good reasons for why that is their agreement. There may not be, but there's no requirement that a judge sign off just because it's been filed and presented. Judges can and do request amendments to the paperwork if it can be fixed on the paperwork, or request hearings to question the parties about any issues that don't quite seem to make sense. So that right would always be preserved so that wild and crazy orders aren't getting through the court just because.
Leslie Cohen, Assembly District 29. If I can add there a couple of things. If we are talking about Clark County and people are using the forms are really detailed. They walk the litigants through dividing up the time, dividing up the holidays, so that hopefully people won't put something in that doesn't make sense. For instance, I always get the example from clients when I'll say to them, what do you want to do with the holidays? And they say, oh, well, we'll split them. And then I'll say, okay, well, what does that mean? If you're talking about Christmas, does that mean the 2 weeks off from school? Does that mean Christmas Eve and Christmas Day? Does that just mean Christmas Day? Does that mean alternating? Does that mean dividing it up? And so the forms are really good at helping the litigants figure out what does that mean for them. On top of that, I would add that even when you have an adversarial case, our judges do tend to defer to the litigants when we're talking about custody and visitation issues, because our judges believe that parents know what's best for their children. So unless we're having an issue where as Ms. McDonald said, there's something that just doesn't look right, usually the court's going to presume these are the parents, they know what's best for their children. Even if the schedule looks a little odd, that's what those parents want to do for those children, and that's going to be what's in the best interest of those children.
Thank you for that, Assemblywoman. I don't see any additional questions at this time, so I would like to open it up in testimony for support of Assembly Bill 227. There's anyone here in Carson City that would like to approach and testify in support? Not seeing anyone. Broadcasting, can you open the lines, please?
Callers, if you'd like to testify in support of Assembly Bill 227, please press star 9 or press raise hand in your Zoom window to take your place in the queue. Again, if you would like to testify in support of Assembly Bill 227, please press star 9 or raise hand in your Zoom window to take your place in the queue. One moment, Chair.
Okay.
Call-in user, you are unmuted on our end. Can you please unmute your device? Call-in user, you are unmuted. Chair, I believe we're having some technical difficulties with this caller. Would you like me to move on?
Yes, and maybe they'll be able to get back in during the process.
Yes, Chair. Callers, if you have recently joined and would like to provide testimony in support of Assembly Bill 227, please press star 9 now.
Yes. Can you hear me now?
Yes, we can.
Yes.
Please continue.
As I was trying to find a room to actually where you could actually see me. I'm in the just running all over the place because I don't know where I'm going here at the federal building here in Las Vegas. And so
That's okay. Please continue.
yes. My name is Dorothy Jean Davis, first of all, and I was just calling in regards to or wanting to give my testimony concerning the solution for the equality and the justice, and this is dealing with the removal of the label of felon on those that have actually completed their sentence.
Excuse me, ma'am. Ma'am, we're on a different bill. Yes. So we've already closed the hearing for that bill. If you would like, you're more than welcome to submit your testimony in writing. You can email the committee. That information's also on the agenda, but we're on a different bill hearing right now.
Yes, which is the revision of the relating to domestic relationship.
Yes,
correct?
We're on Assembly Bill 227.
Yeah. Yes, yes. Well, it still coincides with that because what has happened with that, within the domestic, that whole relationship within the domestic relationship, you have, within my situation, family members disgruntled and trying to use that to railroad, in other words, harass you and then to get you involved with things that are not ethical or legal. And then you call the authorities and nothing can be done, or they claim that nothing should be done.
So, ma'am, are you calling in support? In support of the bill?
Yes, I am.
Okay.
Yes, I am. Mm-hmm.
Continue.
And that's basically it. That's my brief statement there on this particular issue.
Okay, thank you so much for that.
You are.
Chair, the public line is open. There are no other callers to testify at this time.
Okay, thank you. Then I will open it up for anyone who would like to testify in opposition to Assembly Bill 227 here in Carson City. Not seeing anyone. Broadcasting, is there anyone on the line?
Callers, if you'd like to testify in opposition to Assembly Bill 227, please press star 9 now to take your place in the queue. Chair, there are no callers choosing to testify at this time.
Thank you. I will open it up for neutral. Anyone wishing to testify in neutral of Assembly Bill 227? Not seeing anyone in Carson City. Broadcasting, is there anyone on the line?
Callers, if you'd like to testify in neutral for Assembly Bill 227, please press star 9 now to take your place in the queue. Chair, there are no callers choosing to testify at this time.
Okay, thank you. I'd like to welcome Assemblywoman Cohen back up. She does not have any final statements on the bill, so I will go ahead and close the hearing for Assembly Bill 227. With that, the last item on our agenda is public comment. So if there's anyone here in Carson City, there doesn't appear to be anyone here in Carson that would like to make public comment. So I would, broadcasting, please open the lines again if there's anyone on the line that would like to make public comment. Again, this is not pertaining to any of the three bills that we have heard today, but any other issues that are under the purview of this committee. So broadcasting, please open the lines for public comment. And again, we ask that everyone keep their comments to 2 minutes.
Callers, if you would like to provide public comment, please press star 9 or raise hand in your Zoom window to take your place in the queue. Again, if you would like to provide public comment, please press star 9 or raise hand in your Zoom window to take your place in the queue.
Anne Marie Grant, ANNEMARIEGRANT, sister of Thomas Purdy, who was murdered by Reno Police and Washoe County Sheriff's Office during a mental health crisis. I'd like to talk today about another community member tried, convicted, and executed by police, Stanley Gibson, who was born in Las Vegas and was a lifelong resident. He served in the U.S. Army during the First Gulf War. He was a decorated soldier, receiving medals, including the Army Good Conduct Medal, Army Service Ribbon, Saudi Arabia Kuwait Liberation Medal, Southwest Asia Medal, and the National Defense Service Medal. He had an honorable discharge. His mother had to bury her son. His wife had to bury her partner of 11 years. Not only do police murders of community members weaken the public's trust in law enforcement, but it is the community and the taxpayers who ultimately pay for these bad actors. Stanley was 43 years old when he was shot and killed by LVMPD in the early morning hours of December 12, 2011. His wife, Rhonda, said he suffered from post-traumatic stress disorder from his time proudly and bravely serving our country during the Gulf War. Stanley Gibson was unarmed. His jacket would later be returned to his wife, riddled with bullet holes, and his service medals attached to his jacket still. I don't think the general public is aware of how uncommon it is for an officer to be fired. Stanley was killed less than 2 years after 21-year-old unarmed Trayvon Cole was shot by LVMPD in his apartment bathroom. Again, I'd just like to reiterate that the Washoe County Jail has been in lockdown for days on end. These human beings who have yet to be, they were awaiting trial, are being locked down 23 hours a day, days and days in a row. Someone needs to do something about it. Thank you.
Thank you.
Caller, you're unmuted and may begin.
Yes. DOROTHYJEANDAVIS, and I would like to alert the public in regards to those who have been labeled as felons and being disrespected by the community that is hindering and causing great hardship for them when it goes to just being productive citizens. And my concern is that the solution for that and to end the homelessness and the suicides, the baseless suicides in our community, is to remove that label off the people and give them a free chance, because it goes against the abolition law that actually ended the slavery, and it's just making the people lifelong slaves on paper while others are receiving their free labor, and it's hindering those that are coming into this country trying to seek a better life and being even done worse than the citizens of this country. And that is my comment for the community.
Thank you, caller.
Chair, the public line is open and working. There are no other callers to testify at this time.
All right, thank you for that. With that, I would close public comment, and we have finished our work for the day. I know it has been a long morning, but I appreciate everyone's attentiveness and work today. So with that, I will go ahead and close the hearing and see you all back at 8 a.m. tomorrow morning. This meeting is adjourned.